And I think we're going to get started if everybody's just about ready. Welcome to today's Ducks in a Row estate planning session. And this is sponsored by the Seattle Public Libraries, and we have Nancy Sloat joining us here from our friends over at SPL, as well as Tiffany Gorton from KHBB Law. Nancy, do you want to go ahead and do a quick intro for yourself?
Let me see. Hello, everyone. I think I'm not muted anymore. My name is Nancy Sloat, and I'm the Older Adults Program Manager at the Seattle Public Library. So I do what my job sounds like. I design and work with many partners to create and provide programs of interest to older adults, and we define older adults as anyone 50 plus. So we are very delighted to partner with People's Memorial Association today. We're really pleased to do that and to be able to offer this three-part Ducks in a Row series. I just wanted to let you know that you can find other programs in the older adults programming in our special calendar on the Seattle Public Library website. I will put that URL in the chat, and you can go right there to get to programs specifically of interest to those of us who are 50 plus. So thank you very much, and back to you, Beverly.
Oops. Advance the slide a little fast. Wonderful. We're so happy to have you here. And I'm Beverly Trick. I'm the admin for People's Memorial Association, and I'm just going to help do a little facilitating today. But mostly, I know that we're all here for some hot tips on estate planning. Before we get into the good stuff, I just have a couple of housekeeping items for everyone. Let's just go ahead and make sure that all of our participants are on mute, unless you need to share something. We are going to go ahead and record today's session, and then we'll make that available on our website and our webinar library. So if something important happens and you have a second to jot it down, don't worry, there will be a recording. If you do have any questions, feel free to drop them in the chat box. If you're maybe a little bit shyer, feel free to go ahead and directly message myself, Beverly, or Amanda Stock, my boss, and we can go ahead and ask your question anonymously. We're happy to do so. We're here to answer questions. And there will be just a general Q&A at the end, and we'll try and capture everything we can. And if you think of any questions after the fact, feel free to go ahead and get in touch with any of us at People's Memorial after the fact. We'll make sure that you have everyone's contact information, as well as some contact information for Tiffany and Nancy by extension. So just to get this right out of the way, just a little bit about People's Memorial. We are the oldest and largest memorial society in the U.S. I think we're holding our own internationally as well, but that's a talk for another day. We actually were founded here in 1939 in Seattle, so we did just celebrate our 80th anniversary this past year. And we are the only nonprofit in Washington providing funeral education and consumer advocacy. We're one of the roughly, I believe, 73 affiliates nationally of the Funeral Consumers Alliance. And to date, I think we just broke 214,000 members, of which I believe there's about 70,000 members that are currently living. So we're building up a pretty robust following. And in case this is maybe your first encounter with us, just kind of a quick overview of the types of work that we do. Education is one of our biggest focuses, and if you're here, you already know a little bit about us offering free classes and resources. And we're working on bringing those into some newer formats to try and kind of meet the unique needs that we're all experiencing during the pandemic. So like offering this as a webinar. So if you have any feedback about that or any questions, please feel free to let us know at any time. Just like the Seattle Public Libraries, we're working on making our programming the most accommodating and appropriate to what our members and community need. And in service to our passion for supporting our community, advocacy is another huge part of the daily work we do at People's Memorial. We do some state level legislative lobbying, and one of our kind of more recent successes we're very happy to talk about is the recent passing of State Bill 5001, I believe it was, which opened up a couple of new disposition options for Washington state residents. So folks will soon be able to have access to both water-based cremation, also called aquamation, as well as recomposition, which is natural organic reduction. And so those are just a couple of examples of the increased choices that'll be available to folks. Another great passion of ours is increasing the price transparency in the funeral industry and making sure that families have access to the types of resources they need to perform funeral care that meets their cultural and social needs and ultimately prioritizes the needs of individual families and not the funeral industry. Our whole thing is access to affordable cremation and burial, and you can get all kinds of good information off of our website if you are curious to learn more about that, or feel free to reach out to us anytime for more information about that. We're happy to talk about it. So welcome everybody. It looks like we have a pretty good group here. It looks like we just cracked 70 participants. So I'm going to go ahead and introduce Tiffany Gorton, who's joining us from KHBB Law. We've been working with her for quite a while because she is excellent at estate planning questions. And let's see, Ooh, there's her website if you guys want to follow up a little bit about the type of work they do at KHBB. Oh. Tiffany, are you just about ready to get started?
I am. Thank you, Beverly.
Welcome.
All right. Well, I appreciate that. And this is a really special presentation personally because the People's Memorial Association and the Seattle Public Library are both organizations that are very near and dear to my heart. I have been in Seattle over 10 years, 11 years, 12 years. I'm originally from Michigan, but when I first moved here, I learned about People's Memorial Association and became involved. And I actually served on their board for a while, and I'm of course a member. And as Beverly mentioned, I've worked a lot on these get your ducks in a row type presentations for folks to talk about estate planning and probate and wills and trusts and what those things are. But like I said, I've been involved with the PMA for a long time. And so when I learned that they were partnering with the Seattle Public Library to host this and a few other presentations, I was really excited because I'm also an avid reader and an avid borrower and on-time returner, I might mention. For the Seattle or from the Seattle Public Library. And I've partnered with that organization as well to share, estate planning tips and details just with the community so that folks can, be informed. And so all that to say, I'm very excited for these two organizations to get together, which was completely unrelated to my involvement with either of them, but was very exciting for me. And just in terms of a couple of fun things, because I am an avid reader, I wanted to share just a couple of books that I've read. I've had some extra time to read over the last 6 months, as many of you may have, and I really appreciated the Seattle Public Library's online ability to download books onto Kindle and download audiobooks. And so I reread Anne of Green Gables, which was one of my favorite books as a kid. And I really liked that. That was fun to reread as an adult. And I'm currently reading Give and Take by Adam Grant, which is a book about leadership and, mentoring others and things like that. So if you're interested, feel free to put in the chat box what you're currently reading, because I'm always looking for a good recommendation. And with that, we'll kind of move into kind of the substance of the estate planning discussion that I'm here for. And I'd like to start with a quote. In this world, nothing can be said to be certain except death and taxes. Thank you, Benjamin Franklin. That's a quote that we're probably all pretty familiar with. And it's a little bit of I say it a little bit tongue in cheek in my industry because we spend a lot of time talking about death-related things, probates, estate planning, etc., but also taxes, estate taxes, gift taxes. And in terms of what our discussion today is going to focus on, you may know this, that at the federal level, there is an estate tax for folks that are here in the U.S. And the exemption amount is currently $11,580,000 per person. So that doubles to over $23 million for a married couple. So I hope to have an estate tax problem someday. I don't currently. But one thing is, in Washington, we have our own estate tax, which has an exemption amount of $2,193,000 per person. And so sometimes folks will overlook or forget about the state estate tax, which is really important for Washingtonians, particularly in King County, because if you think about having, some real estate here, maybe a retirement account, a life insurance policy, folks can get to that exemption amount relatively quickly. And so that's something to be cognizant of. So that's just something I wanted to kind of mention, to put on your radar, that there is an estate tax here in Washington, and there is some special planning that goes along with that. And so we're not going to focus today on estate taxes because there are a lot of nuances there, and that's not something that necessarily affects everybody. So we're going to talk more about just general estate planning foundational tools, and a little bit about the probate process and selecting executors and powers of attorney. But if you do have some specific tax questions or any other follow-up questions, feel free to email me and put, PMA library ducks presentation in your subject line, so that I know where you're coming from, and I can review that and get back to you, because I won't be focusing on it during this discussion this morning. But again, taxes are one important reason to plan, but folks, the other inevitable, as Benjamin Franklin said, is death. And so folks really have a lot of reasons to plan, making sure that their minor children or minor grandchildren, are properly taken care of, if that's something that's important to you. Maybe you have a second marriage, and that, what is it, roughly 50% plus of the marriages currently are second marriages, or have, folks with prior spouses. And so making sure that you properly plan for your surviving spouse, and if you have children from a prior marriage, for those children. One other organization that I care about and work with a lot is the Seattle Humane Society. And I say that because pets are a really important part of estate planning as well. They're treated as property here in the state, even though some of us can't imagine life without them, or them being called property, so to speak, but making sure that you have appropriate planning for our furry family members, as it were. Philanthropy is another thing. Shameless plug here. If you want to leave, funds or assets to organizations such as the People's Memorial Association or the Seattle Public Library or Library Foundation, those are things that are important in terms of driving estate planning, making sure that, things are buttoned up. I spend, my firm, KHBB Law, is a boutique firm. We do all trust and estate work. We do planning, we do administration, meaning probate, trust administration, and we also do some trust and estate litigation. And a lot of my practice is actually centered on that type of litigation. And so I see things when folks have either not done planning, or maybe haven't planned properly for their particular situation, and when things go awry. And so when I'm talking with clients, one of the things that I say, maybe everybody gets along right now, or, things seem to be moving along smoothly, but wanting to make sure that you have a clear roadmap so that folks are set up for success, and avoiding litigation can be another reason to kind of drive estate planning. Basically, at the end of the day, estate planning is really about people. It's making sure that you're making your passing, your death, as easy on your loved ones and on those you leave behind as possible. And part of that is, who do you want to have grandma's china, or your strand of pearls, or your coin collection, or, any number of things, holiday decorations, things like that, tangible personal property that might not necessarily be of significant monetary value, but is important to you and would be important to the folks that you might direct those specific items to go to. Really importantly, who do you want to make decisions for you if you become incapacitated? We're going to talk about some of those tools in terms of healthcare decisions, financial decisions, and then kind of some of the bones of that roadmap for our assets. But basically, at the end of the day, estate planning is very individual. And I like to say that estate plans are like shoes. Not everybody wears the same size, and not everybody wears the same style. So thinking about what works for your sister or your neighbor might be a little bit different than what works for you. They're very personal, and they are really boiled down to the people in your life and your values and your intentions. And so with kind of that, those kind of principles in mind, I want to talk a little bit about the foundational estate planning tools. First and foremost, you may have these, or you may have heard of these, you may have served under one of these documents, and that is a durable power of attorney. One for finances and one for healthcare. And those can be combined in the same document sometimes, but making sure that there is an agent for both finances and for healthcare. I think that this is really the most important piece of a foundational estate plan, because these are documents that really take effect when you're still living. And that is, your existence and your care, both financially and in terms of healthcare, are really the most important thing. It's important what we do with our assets and how those are distributed, but my human self and how I'm cared for during life is certainly most important to me. And so those documents, the power of attorney, again, can be, one or two documents depending on, just the style of the drafting, but one for finances and one for healthcare. And what do those do? What they really do is they put somebody on deck, so to speak, to make sure that there's somebody there to assist with my finances and my healthcare in the event that I'm not able to do so. So we can talk all day long about all the things, bad things that could happen to our human bodies, and we still wouldn't think of every set of circumstances that could come up. But what this document does is basically provides for a person who can be on deck. Oftentimes that is our spouse or our partner, and then making sure that there's also a backup for that person, a sister, a brother, a child, an adult child, an adult, any adult family member, a friend, somebody who's close to you that you trust and can carry out your wishes in terms of your finances and in terms of your healthcare if you're not able to. So be that for a season, you're having some health issues and you're unable to manage those things for a period of time, or long term. In terms of, folks living longer, most families, I know my family and my husband's family have both been affected by Alzheimer's or dementia. And that's something that most families have encountered in one way or another. And oftentimes that's really where people's mind goes when you're talking about having an agent for healthcare or for finances, is when you've lost capacity for the long term. You're no longer capable of managing finances or healthcare and need somebody to step in to help with those things. In terms of the financial piece, to start with, what does that look like? The agent for finances can step in and say, all right, I'm going to make sure that, the mortgage is paid, or the rent is paid, the property taxes are paid, your monthly Visa bill that comes in the mail is paid. All the types of financial things that you and I do typically on a monthly basis. We sit down with our checkbook, or we sit down at our computer and make sure that all of our services are paid for, our cable, our internet, etc. That are, if you're of the certain age where you're taking required minimum distributions from your individual retirement account, etc. All those types of things that right now I manage for myself and you manage for yourself. But at some point, if there becomes a time where you can't do it, having somebody that is able to step in and manage those things appropriately. On the healthcare side of that, making sure that somebody can step in and manage your healthcare, meaning communicate with your doctors and your healthcare providers about treatment. What are the options? Asking questions. Many of us see this with aging parents or aging grandparents, where folks just might not be asking the questions or evaluating the options and need some help. All the way up through, no longer able to manage any of those things and really need somebody to kind of take control, so to speak. But just making sure that my healthcare is managed in the way that I would do it if I were capable of continuing that. And that agent under power of attorney for healthcare and for finances is oftentimes the same person, but it can be different people too. If you have one person who is, their strong suit is numbers and they're very responsible financially, and they run their household budget in the same way that, you would, then that person might make sense for finances, but maybe not necessarily for healthcare. What you want to do when you're thinking about who you would appoint in those roles is almost like a job interview, because I need to tell you, it's not an honor to serve in those fiduciary roles. It's a job. And so making sure that you have the right applicant, so to speak, for the position is really important. So making sure, you might have 3 children and you say, oh, I should name my oldest child, but your oldest child maybe has 6 kids, 5 dogs, and 3 cats, and a full-time job, and a lot of things going on that might not render that person the most able to serve in that capacity. And that's okay. What you're doing is really looking to see, who has similar financial values to me and who is going to get the job done appropriately. And same with healthcare. Maybe you want to think through religious things. Is this person going to be able to make difficult decisions on my behalf according to what my religious beliefs are? Do they differ from my agents? Or, thinking about maybe being in that position with your own family member or a friend. It's a really hard call when we think about when somebody might be permanently incapacitated or in a permanently vegetative state where they're not going to recover, and having to remove that person from life support. My stepmom, we lost her at a very young age. She was 55. And my dad had to make that decision. And the one sliver of positivity that I could find there is that they had had many, many conversations about what their end of life values were and what was important. And my dad knew that she would not want to remain on a ventilator, etc. And so he was able to do that, and just making that a little bit easier for your loved ones, and certainly making sure that your loved ones are clear on what you would want in those circumstances is really the driver behind the healthcare power of attorney and healthcare directive. And so again, when you're thinking about who to appoint in those roles, just making sure that you're appointing folks that can get the job done and get the job done the way that you want it done. In terms of one of the other foundational tools, a disposition of remains statement. Beverly was mentioning some of the successes that Washingtonians were real pioneers here. We have aquamation, we have human composting. So, we have cremation, we have burial. What do you want done with your human remains? That's something that you can direct. And so, including a statement, either a standalone statement in a disposition of remains statement document, or including that under your power of attorney, that type of direction is important. And it's really, it's something that might be very important to you in terms of how your human remains are handled. And I was just working with a client this morning, and she said, I want to be cremated, and I want my celebration of life to be catered on a boat with a DJ. So some folks really get into kind of thinking through even what their memorial might look like. And so those are all things that you can, share with your loved ones. You can put those in statements. But most importantly, how do you want your human remains to be processed? Do you want to be cremated? Do you want to be buried? Do you want to be aquamated, or do you want to be recompositioned or recomposed? So thinking about those things. And that will really help with family relationships, avoid, second guessing. What would mom have wanted in terms of kind of her last distribution, so to speak. The other tools that we're going to talk about, and these are probably discussed a lot. People often talk about their wills, or, just in conversation, we'll be thinking about it. It's something that seems to always be in the back of folks' mind. And interestingly, when I was a law student several years ago, I did a lot of work for a 60+ clinic, meaning that it was for folks that were over 60 who hadn't done any estate planning. And it's very interesting to me to see, even with my own clients now, how many folks have been really putting putting off their planning for a long time. I have some clients who are in their mid-60s that reached out and they said, we're trying to get our adult paperwork done, Tiffany. We need your help. And so that's what I help with. I help with the adult paperwork, as it were. But one question I like to ask is, and you can raise your virtual hand, I guess, or raise your hand in your home, who has an estate plan that's involved in this conversation today? Well, everybody should be raising their hand at their home, because even if you don't have a will or a trust, Washington has said, here's what's going to happen to your assets when you die. So that's called dying intestate. So if you do nothing, if you don't execute a will, if you don't set up a trust, then you die and your assets pass according to the laws of intestacy. So they go, to your spouse, down to your children. If you don't have them, up to your parents, out to your siblings, up to grandparents, and so on and so forth. So at the end of the day, we all have estate plans, whether or not they're of our own choosing. But I do have some folks say to me, well, Tiffany, I don't have an estate, so it doesn't matter. Or I don't need to do this yet. I don't have an estate. Well, you're right. If you're telling me you don't have an estate, you do not have one, because you don't technically have an estate until you're deceased. But one thing to think about that's important, and I led with this at the beginning of our conversation, is it's not always about money. It's not always about the size of the estate, the size of the assets, whether it's taxable or not. It's about people. And so just making sure that, you might just have a Buick and a base fiddle, but making sure that those things pass to the person or people that you want to receive them is really what's important. Don't leave your family guessing. And if you have somebody that you want to leave items to, then, we have to write it down. So in terms of kind of what the tools look like, wills are probably something that you're pretty familiar with. And the reason that I say that is, in Washington, most Washingtonians, probably 90% of Washingtonians, are very well served using a will as their primary estate planning tool. And the reason is, in Washington, the probate process is not as onerous as it is in some other states. So some folks will say, oh, I have to avoid probate. I have to avoid probate. And my question to them is, why? And it sometimes they do need to. If you are a California resident, then yes, you absolutely want to avoid probate. But like I said, in Washington, it's not as onerous as it is in some other states. It's not particularly expensive. It's not a clogged system. It's pretty streamlined. You pay your $240 filing fee, and then the personal representative or your executor is kind of off to the races, so to speak. So at the end of the day, there are a couple of times when folks who are Washington residents, might want to use what's called a revocable living trust, and we're going to talk a little bit about that in a few minutes. But typically, a will is a tool that works very well regardless of the shape or size of the person's assets. And so let me kind of back. Is something that has kind of gotten a bad rap, so to speak. It's a little bit of a dirty word in our minds sometimes. And really what that is it's a court supervised process of kind of overseeing payment of creditors, gathering of assets, and ultimately distributing those assets according to either the laws of intestacy. Under a will, you would have under your will, which is a roadmap. But probate can also be required if you don't have any planning done, and then you would pass assets under the laws of intestacy. But in terms of what that looks like I said, it's fairly inexpensive. When somebody dies and you're the executor or the personal representative that's appointed under their will, you file that will with the court. You tell the court, basically, this person has died. I have been appointed as executor. I need the authority to gather their assets, pay their creditors, and distribute those assets according to their will. And the court gives the personal representative what's called letters testamentary. It's a one-page document that basically says this person, Tiffany Gorton, has the authority to manage the late Mr. Smith's assets, to distribute those to beneficiaries, etc. And so then the executor comes along with their authority, and they give notice to creditors that the person has died, and that basically says this person is deceased. If they owed you money, speak now or forever hold your peace, because you're going to be barred at some point in time from making that claim. And then the personal representative pays the appropriate creditors, pays final credit card bills, final taxes, files your final Form 1040 if it's required, files any estate transfer tax return if you have assets at the levels that we talked about before. Remember, at Washington, it's a little over 2 million, and at the federal level, it's a little over 11.5 million. So that's really what the process looks like. And they kind of administer all those pieces, kind of the final administration of one's financial life, as it were, and then makes the distributions to the beneficiaries according to the terms of the decedent's will. What is a probate asset? What goes through probate? And kind of the easiest way to explain that is what doesn't have to go through probate. So what are non-probate assets? If you have joint bank accounts that have a survivorship, right of survivorship on them, meaning, like, for example, my husband and I have a checking account that is a joint account with rights of survivorship. If one of us dies, the survivor owns the account. Some folks might have that with children, adult children. They put their oldest on their account, and that's a joint tenancy account. And so when the mom dies or the dad dies, that account belongs to that person that they've added as a joint tenant with rights of survivorship. I will caution you here, because like I said, I do spend a lot of time doing litigation. Make sure that you have your accounts titled in a way that is exactly how you intend. Some financial institutions will add that right of survivorship language as kind of an automatic, and you might end up disinheriting some of your beneficiaries that way. If you have, one big account and you add your oldest child to it for check writing purposes, but the bank doesn't understand that and puts rights of survivorship, and then you die, that oldest child owns those funds and does not have to distribute them or share them with siblings. So it's important to make sure that the titling on your accounts is indeed what you intend. And so think about that with respect to the rights of survivorship. But again, it passes automatically. It doesn't have to go through the process of probate. If you have property that's subject to a community property agreement among spouses or registered domestic partners, then those assets that are subject to that agreement will pass according to that agreement, more like a contract. And so there's not going to be a probate requirement. Property that's held in trust is not going to be required to go through probate because it's not owned by the decedent. It's owned in a trust. And that is one of the things we'll talk about in a few minutes with revocable living trusts. That is why that is a tool that avoids probate, because if they're properly funded during life, then rather than owning assets outright, the assets are owned in the trust, and so therefore they avoid the probate process. Life insurance policies and retirement accounts, other types of assets that have beneficiary designations associated with them. If you have a beneficiary designated, a third to each of my 3 children, or all to Suzu Q. Any types of contracts like that, assets with those types of contracts are going to pass automatically according to those contracts. They don't require the probate process. So in terms of kind of what a will looks like, we talked about kind of the probate assets and what the will governs. The will governs your probate assets, not your non-probate assets. Those pass automatically. So everything else is going to fall under the terms of your will. And sometimes folks say, you know what, I want everything to pass under the terms of my will, so I'm not putting a beneficiary designation, or I'm designating, my estate as the beneficiary. And that can make sense in certain circumstances. And so just, it depends on your individual circumstances. But in terms of reasons for executing a will, we talked a little bit about minor children and minor grandchildren. And so oftentimes folks will say, I really want to set up, if you have particularly minor children, they can't technically inherit. And so rather than having, these assets that are held until they're 18 and then they're given a pile of cash, so to speak, folks will oftentimes include trust language under the terms of their will to ensure that that minor, when they, they are able to receive benefits from the trust during their minority, but also to ensure that into early majority, meaning, they're 18, they're 20, they're 25, they're younger adults, that they are set up for success by not necessarily having access or unfettered access to the assets. I have one example that really is burned into my brain with respect to having assets or having trusts set up for minor children under the terms of a will. It's not something that you're setting up during lifetime necessarily, but certainly if there are minors that you want to benefit with your assets at the time you die, including some trust language under your will or in a revocable living trust is really, it can be important. I did several years ago, I worked on a probate estate administration for a father who died suddenly, and his daughter was like 17 and a half. So during the probate process, she was driving around in his Porsche, which probably was not, well, one, it wasn't appropriately insured for that, so she had to be told to stop, but also probably not what her father intended. And that estate ended up being about $1 million. So that is not insignificant. It's certainly not insignificant to Tiffany Gorton. But at the end of the day, he didn't have any planning done. He hadn't done a will. So he died intestate. So his 17-and-a-half-year-old daughter was his only heir. And she was basically set to receive $1 million in assets, including a Porsche, upon graduation from high school, before she even went off to college. And that is really probably not what her dad would have intended. Tiffany Gorton at 18 was not anywhere close to inheriting anything, nor am I now. But I know that 18-year-old Tiffany probably wasn't in a good position to just simply be receiving assets of that size at that time. And so oftentimes when folks do have minor children or grandchildren or other minor beneficiaries, including some language that allows for like distribution ages, for example, meaning, you give your trustee broad discretion and then allow distributions at age 25, 30, 35, etc., or distributions for education or purchase of a home or starting a business, things like that. And one of the really important pieces under the terms of your will is, like we talked about a little bit with the powers of attorney, is you're appointing a fiduciary, you're appointing an executor, you're appointing a personal representative, and making sure that you have the right person for that job, again, is very important. So it's a job, not necessarily an honor. And so folks sometimes will say, well, I have 3 kids, I should name all 3 of them, they can act together. Well, you don't want to get too many cooks in the kitchen. And sometimes that can work. But sometimes it doesn't make sense, and that's okay. Just, having an individual, or even if a professional fiduciary makes sense given relationships, or maybe you don't have children, or your children live out of state and you really want somebody local that can, easily wrap things up. You can name, a child or an adult child, a family member, a friend, a neighbor, a professional fiduciary. There are fiduciaries that serve as executors, they serve as trustees, and they do it for a living. They're professionals. And that's not necessarily, I have to have a big bank trust company. There are, very small shops, even locally here in Seattle in the King County area, that do that. But just making sure that, you have the right person in that position for the job, because they're going to be acting on behalf of your beneficiaries, under the terms of either your will or your trust, and making sure that that person is responsible financially and can manage those assets and get the job done. Again, maybe you say you want to name your oldest, but they have 6 kids, 5 cats, and 3 dogs, and are just starting a business, or any number of things. Just having somebody who, one, is going to be responsible and trustworthy, but also has the ability in the room, so to speak, in their life to serve in that capacity. I mentioned that in terms of the distributions to either under wills or under trust, there's kind of 2 different foundational planning tools. And we're going to talk about trusts in just a minute. The other important piece that I wanted to mention with respect to wills is making sure that you're able to appoint a guardian if you have minor children. So a lot of my clients kind of run the gamut in terms of shapes, sizes, ages, asset levels. But one primary group that I work with oftentimes is young families. So you have weddings, babies, funerals, liquidation events. Those are all things that get people thinking about their estate planning, particularly babies. If you're growing your family and wanting to make sure, one, that there's a trust established under your will for assets for that minor, but also including language to appoint a guardian for that minor child in the event that you and the other parent are deceased, something happens, and your will is where you do that. And so in terms of kind of some of the advantages, you name a personal representative, you can design specific bequests for family, friends, charities, etc. However you want to slice and dice assets, you are in charge of how things are distributed under your roadmap, under your will. And that, again, because probate's not particularly onerous here in Washington, that is a tool that's used by a lot of folks. The other that you may have heard of is the revocable living trust. And again, I mentioned at the beginning that estate planning is really individual, and it's kind of like shoes. Not everybody wears the same size or the same style. And so a lot of times I'll get folks that say, well, I need a revocable living trust. And so I ask them, why? Well, I know that so-and-so has one, or one of my favorites is there's a Susie Orman kit that's available online, and she's a huge proponent of revocable living trusts, but it makes sense in some states, but not necessarily in Washington. Oftentimes I'll ask folks, though, if you have out-of-state real estate, that's a time where a revocable trust might make more sense for you than a will, because you can avoid having an ancillary probate in that other state. So if you have a place in Idaho, for example, rather than having a probate in Washington and a probate in Idaho in order to manage and administer that property, if you set up a revocable trust and you title the property in Idaho in the name of that trust, you can avoid having your personal representative, your executor, having to open a separate probate there. So that's a big time, that's a biggie when folks are thinking about which tool makes sense for them. Some folks just say, you know what, I'm more comfortable with the trust. My parents had a revocable trust, or, any number of reasons, and that's okay too. It's entirely up to each individual, kind of what tool makes sense for them. Sometimes folks will say, well, I want to, I have this one black sheep. I know that this brother, he loves to make trouble, and I don't want him coming along and trying to contest my will. Well, it's hard to prevent somebody who wants to stir things up from stirring things up, regardless of the tool. But at least with a revocable trust, he wouldn't necessarily, as a non-beneficiary, have access to that document. Whereas a will, after you die, is filed with the court, and so then anyone who wants to go on the court's website and view that can view it. So sometimes there's a little bit more privacy that can be involved if that's something that's important. And again, it's entirely individual, and it's really up to each person which type of tool they like to use or want to use. And you don't usually put account numbers, or certainly not social security numbers, or that type of identifying information under either of these documents. So it's not that all of your financial information is going to be filed with the court under the terms of your will. But again, just not necessarily having the beneficiaries listed under the terms of a trust to make it a little bit more private. Because the only person who's entitled to see that trust is the trustee and the beneficiaries. So if somebody's not a beneficiary, they're not entitled to the document. In terms of kind of some of the differences between wills and revocable trusts, a will is really kind of inactive, so to speak, until you die. So you think through kind of the roadmap, you work that out, you sign it, and then you put it away until you're gone, or until you need to make a revision. Whereas a revocable trust holds assets during your lifetime. So for example, you have a house in King County, and you set up a revocable trust, you title that house as Tiffany Gorton, trustee of the Tiffany Gorton Trust, instead of Tiffany Gorton as an individual. Same thing with certain accounts. You change the title of, Tiffany Gorton's Bank of America account will become Tiffany Gorton, trustee of the Tiffany Gorton Trust Bank of America account. And that is the way that probate's avoided, is when you title assets in the name of that trust, they're no longer owned by you as an individual. And so then they don't have to flow through the probate process. So that's really how that becomes a probate avoidance tool. Some of the disadvantages, they're not necessarily as common as wills, and they can be a little bit more expensive on the outset to set up, because they're a little bit more of an involved document. If you do decide to execute a trust agreement, you want to make sure that your accounts, again, reflect your current intentions. So ownership on bank accounts, on financial investment accounts, etc. You just want to revisit what those account documents say in terms of ownership and what they say in terms of beneficiary designation, to make sure, one, that if you intend to properly fund the trust, that it is indeed funded, and two, to make sure that whatever the beneficiary designation or ownership of title reflects your current intentions. In terms of establishing a revocable trust, it's very similar to a written contract. You kind of, it's prepared and it gives the same type of direction as a will, but again, it's something that becomes kind of active immediately versus being kind of dormant until death. And under the terms of a trust, you appoint a trustee as opposed to appointing an executor. That job is a little bit different than executor, but there are a lot of similarities. So if I'm setting up my own individual, my revocable living trust, then I appoint myself as the trustee. So I continue to live in my house. I continue to pay my mortgage. I continue to pay my taxes in the same way that I would, before signing that document, but the titling is different. And I'm now the trustee for my own trust. And then what I also do is I appoint a successor trustee, so that in the event that I either become incapacitated, like we talked about with powers of attorney, or I die, there's somebody who comes along and acts as the successor trustee, and say that I'm deceased in this example. That successor trustee comes along and is able to administer the trust assets and make distributions according to the terms of the trust, very similarly to how an executor or a personal representative acts under the terms of a will, except there's not a probate process. They're just following, what the terms of the trust say, in the same way that the roadmap for a will works, but they're a trustee instead of a personal representative or an executor. There are a couple of misconceptions about revocable trusts, and I think that it's important to call them out because they're very, very common. First, there's no creditor protection. So if I set up a trust and I put my house in it and my securities accounts in it, etc., the Tiffany R. Gorton revocable trust, and then I go and do something negligent, like crash my car into something or someone, and they sue me, they can still reach those assets. So you're not protecting them, because you still have the benefit of those assets. So there's not going to be creditor protection. If I go and rack up, a ton of debt, then I still have to pay that. My assets are still available in terms of debt collection. It's not, they're not protected under the terms of a revocable trust. Now, there are some trusts that do offer those types of protections, but they're different. They're not this type of trust. This is a foundational tool that is kind of like a will substitute, and there is no creditor protection associated with it. There's also no tax benefits. Meaning I still have to pay my individual income tax. If I die and my assets in the trust are more than that $2 million amount for Washington, or more than that $11.5 million amount for the federal estate tax, my assets are still going to be susceptible to those taxes, in spite of the fact that I've set up a trust. Now, again, there are other trusts that do have tax benefits that are part of tax planning, but this is not that type of trust. Again, this is a will substitute type of trust that doesn't have any tax ramifications or benefits to it. Again, my income and my expenses will continue to be reported on my Form 1040 in the same way that I always have, and those assets are going to be included in my estate for estate tax purposes. A couple last items to note are, again, I want to reemphasize making sure that any of your assets that you currently have, be it life insurance, retirement accounts, other investment accounts, bank accounts, real estate, etc., that all those things are titled and have beneficiary designations to the extent possible, according to the terms of what you actually intend now. Sometimes folks will get an insurance policy and then they name one beneficiary or another, and then 20 years goes by and that's not who they actually intend, but they forget about it. They forget it even exists. I have clients all the time who I don't learn that they have $1 million in insurance until the second or third or fourth conversation. And so making sure that you're, one, that you know what you have, and two, that any beneficiary designations represent your current intention. And the other thing to think about is, in terms of tax planning, is again, life insurance is one of the biggies that folks forget about in terms of thinking about that 2 million threshold for Washington and the 11.5 million threshold for the federal level of estate taxes. So if you include your life insurance in that big number, because that's something that is indeed included for estate tax purposes. So if you want to think about doing any lifetime estate tax planning as part of your estate plan, you want to make sure that you're working with the specific good numbers and make sure that you're not leaving anything out of the equation, so to speak. So in terms of kind of what I'd like to do for the next couple of minutes, we just have a few, but I'm happy to take some questions if folks have them. And I do have a couple that I can see. So can you explain the difference between an estate plan and a revocable trust? Well, we talked a little bit about the two primary tools being a will or revocable trust, and whichever you select is going to be what your estate plan falls into. That includes kind of your will, your trust, your durable powers of attorney, etc. That big umbrella of estate planning or estate plan, all those types of documents fall under it. And we did talk about the differences between a will and a trust. The other thing that I have is my mother lives in Utah. I'm her executor here in Washington. If I need legal advice, should I hire a lawyer in Washington, Utah, or both? And the answer to that is you would want to hire counsel in the state that the probate's occurring in, which if your mom lives in Utah, it would likely be Utah, because unless she moves to another state, she's a Utah resident, and that's the state that would have jurisdiction. So if you need counsel regarding your service as her executor, then you would want to use Utah counsel. If she has assets in Washington, if there's real estate here or in another state, then you may need to consult counsel in that state as well. But just based on her being a Utah resident, that's going to be the primary state that you would want to talk with counsel in. If our home is only titled in one spouse's name, does that make it difficult after the death of one? If it is only titled in one of the spouse's names, you'll need to work, you'll get a death certificate, etc., and you'll need to transfer that regardless of whether it's in one spouse or both spouses' names. You need to take the deceased spouse off the title after death. And so even if it's just in that person's name, then you're going to have to move likely through the probate process in order to get the surviving spouse onto title according to the terms of the will. But again, even if they're both spouses, their names are on that title, you'll have to remove the deceased spouse after one dies. Is there an established fair fee that I can mention in a will to pay an executor for their work? That's a great question. So there's no involuntary servitude. So personal representatives, executors, trustees, agents under powers of attorney, all those folks are entitled to reasonable compensation for their time and for their work. Because as I said, it's a job, not necessarily an honor. So they are entitled to payment regardless of whether you put that in your document specifically. Washington law just provides that they are indeed entitled to reasonable compensation. But sometimes folks say, you know what, I would really like to give $5,000 as a gift to this person, as for their willingness to serve in this capacity. And you can certainly put that in as kind of a an additional gift, so to speak. And sometimes folks will say, even though folks are entitled to be paid for those services, sometimes the person who's serving, the executor, feels a little bit funny about, charging a family member's estate or something along those lines. And so I tell clients, if you think that somebody might be concerned about that, then I would include a sentence or two that basically says, I expect my personal representative or executor to charge a reasonable fee, and I want them to do that. Just making it clear that that is indeed, what mom wanted, or, whoever the deceased person is and whatever that relationship is there, that's what they wanted. Can you say what goes into a codicil and how it can be changed in lieu of changing a will? That may be too involved for this purpose. Sure. So a codicil is something that essentially revises or makes a change to a prior will. And that can be, as simple as, correcting the spelling of somebody's name, or making one small change to, I want to take out this gift, or I want to add this gift. And you still have to sign it before two witnesses in the same way. The execution requirements are the same as you would for signing your will. But it's just, a little bit of it's a shorter document. So it might say, Section 5A of my will executed on June 21st, 1983 is going to be removed and replaced with this language. So again, it's those execution requirements, meaning you have to sign before two witnesses, which is the same as signing your will, are required. But a codicil is usually just used to make some minor changes versus a complete overhaul of an estate plan, so to speak. What is the advantage of an irrevocable trust with an IR at the front, irrevocable, versus a revocable trust? That's a good question. There can be a lot of advantages. There are a lot of different types of irrevocable trusts, and typically irrevocable trusts are done as part of tax planning. Because if you're in a position to transfer assets to an irrevocable trust, meaning you can't change the trust, you can't take the assets back, you've made a complete gift to that trust, it removes assets from one's estate. So then they're not included after death in that $2 million or $11.5 million calculation for estate tax purposes. So that's really what the primary advantage of using an irrevocable trust is usually for tax planning purposes. But again, you give up control when you make it an irrevocable trust. Does a revocable trust have to file a federal income tax return every year? That's a great question. The answer is no. A revocable trust does not file a federal income tax return. You continue to utilize to report your own income on your 1040. You continue to take your own deductions, be it mortgage interest, etc., on your own 1040. A revocable trust does not have, during your lifetime, does not have a tax ID number. They don't file any taxes until somebody dies. That is when there would be potentially an income tax return that would have to be filed if there's income in the trust during the administration process, etc., but not during lifetime. Is a property like a home titled for two individuals with the right of survivorship? Does that avoid probate? If there's an asset that has title on it with right of survivorship, then it's not going to be required to be probated because it's going to pass via that contract. That titling of the rights of survivorship means that the survivor is the remaining owner on that asset. When will the Washington tax exemption be reset to reflect current times? That's a great question. I don't know if this person is a lawyer or not, but I'm smiling because the Bar Association, which I participate a lot in leadership, we're currently working to reset the exemption for Washington for the estate tax in order to have it adjusted for inflation. There were a couple of items that were overlooked under some legislation over a couple of years ago. And so as a result, that $2 million figure hasn't increased, but we're working on correcting that. So that should be coming down the pipe, probably not this legislative session, but probably next year. And again, it's not going to be a huge difference. It's not going to jump from 2 million to 11 million to follow the federal. It'll be the 2 million adjusted for inflation. So it'll be a little bit more than 2,193,000. What if an executor does not divide money 50-50 as stated in a will, but gives money to a charity so that the second person gets nothing? If an executor doesn't distribute assets under the terms of the will, they're incorrect. They're breaching their fiduciary duty, and the beneficiaries under the terms of that will would indeed have recourse against the executor for making that distribution that was improper, and the executor would be personally on the hook, personally liable for that. Okay, I think we're a little bit past time, so I want to see from Amanda and Beverly if I can just answer these last 4 questions, and then we can close up shop, so to speak. How does that sound?
Actually, you know what? We do still have plenty of time, and it looks like we've got some good questions flowing in. So if you've got the coffee in you to keep going, we'd love it if you'd keep going.
Great. Well, let me finish these 4, and then after the program, certainly if anyone thinks of anything that they didn't get to ask, shoot me an email, and I'm happy to check in.
Okay, it looks like there's a couple questions lurking in the chat box as well, so I'll pull those out for you after you work through these.
Okay, thanks.
Mm-hmm.
So with stock rising, is Washington estate tax based fair market value at the time of death, i.e. 2 million ceiling? Will it be passed if Tesla stock escalates? Well, this is a terrific question. In terms of that $2 million mark, that is evaluated and valued, assets are valued as of the date of death. So it depends on whether the person died holding that Tesla stock today or 6 months from now, depending on what the date of death value is. So that is how that is calculated for purposes of estate tax reporting and estate tax allocation. Can you sign your will and have it notarized remotely in Washington, or you still need 2 witnesses? So in order to have your will be effective under Washington law, you need to sign it in front of 2 witnesses. So it doesn't necessarily, a notary is not required as part of having a validly executed will. 2 witnesses are required. And so right now, remote notarization doesn't apply to wills because there's not a notary requirement. We are working on, again, because I'm involved with the Bar Association and involved with a lot of legislation, there is going to be a bill coming down the pike for electronic wills, and that will have that type of electronic witness component to it. But right now, a will needs to be actually witnessed, and meaning physically present. Why would you care about whether assets are non-probate or go through probate? That's a good question. Some folks say, I just want to make it as simple as possible for family members. And if you don't own real estate and you have assets like life insurance or investment accounts, and you can simply put beneficiary designations on those, and that meets your intentions, then you might not want things to go through probate. And so you can certainly do that. Real estate is going to be the big trigger there. If you have assets over $100,000 or there's real estate involved, and those assets that over 100,000 do not include beneficiary designations, then a probate's going to be required. So there's not as much of a care, so to speak, about probate or not here in Washington. It's just a matter of what your asset makeup is and whether or not those assets are going to have to go through probate. Okay, just a comment. Contingent beneficiaries are important too. That is true, Becky. Thank you for pointing that out. Contingent beneficiaries, in the same way that having a successor fiduciary appointed, having a backup to your backup is really important. Oftentimes, will language will have, all the beneficiaries that you want in terms of family members or charitable organizations. And then it's important to have kind of an alternate distribution clause, which oftentimes will say to my heirs under the laws of intestacy, or, to XYZ organization, or if that organization is not any longer in existence, to a similar organization, etc. Does a sole proprietor need completely separate will and trust for business side of things, or can that be worked into the personal will? That is something that can be worked into the personal will. Your assets under that business would be part of your kind of global assets that can be distributed under the terms of a will. But that's something that you would really want to talk through kind of what that business is, what those assets are. But again, making sure to be certain that the way that the assets are titled are not going to make them subject to distribution to some other beneficiary that's already been appointed versus what your will says. Does payable on death bypass any probate on property? Yes, payable on death, transfer on death, those are beneficiary designation terms. And so any property that has a pay on death beneficiary or a transfer on death beneficiary or other type of a beneficiary designated is not going to be required to go through probate. Okay, perhaps you already said this, but can you describe what probate means exactly? Certainly. So probate is a court supervised process of the administration of a deceased person's assets, their debts, and kind of their final administration. So paying the final income tax return or filing a final income tax return and paying any tax due, gathering all of the assets and making distributions according to the terms of will or under the laws of intestacy. And probate is just kind of the court supervising that process, not meaning that they're heavily involved with every single step, but it's a forum that allows a person to receive the ability and the authority from the court in order to manage the assets of the deceased person in order to distribute them.
Okay, let me just double check that we got all the questions out of the comments. I think a lot of those folks doubled up and submitted it via the Q&A feature. So let's see. Okay, there's a question about the Washington State exemption. Would you clarify what the difference between a durable POA and a general POA is?
Certainly. So a durable power of attorney, that word durable in there, in the language of durability under the terms of that document, mean that that power of attorney is going to be effective regardless of whether or not the person has capacity. And that's important in the under your estate plan, because it's precisely when you lose capacity or when you lack capacity that you want somebody to be able to step in and manage finances or manage healthcare for you. A regular general power of attorney is something that folks will sometimes execute if you think about like real estate transactions. So say, for example, I'm working on purchasing a house, but I'm going to be overseas, and for whatever reason, I can't, manage that purchase. I can give somebody else, I can sign a general power of attorney, giving that person authority, some other person authority to act on my behalf with respect to that transaction. But it doesn't have anything to do with, me not being able to manage my own finances or manage my own healthcare. So the durability language is important. You want it to be in your power of attorney in order to make sure that when you lose capacity, or if you lose capacity, that power of attorney remains valid.
Wonderful, thank you. We have another attendee who's curious. When one spouse dies, for the Washington estate tax, do you consider all of the community property assets? So when you get to the 2.1 million total, do you consider half of the assets the couple owns together?
So the way that the deceased person's assets are calculated is going to be their share of the community and any separate property that they own. So their half of the community and any of their separate property is going to be totaled up. And this is a little bit, this is trending into kind of more of a contact me if you have some more specific questions about this, because you do want to make sure that your calculation is accurate, but also there's some planning that you can do for the surviving spouse in order to ensure that you're utilizing both the deceased spouse and the surviving spouse's exemption amount. But in terms of the calculation for the deceased spouse, it's going to be their half of the community and their separate property. And don't forget that there's an unlimited marital deduction in terms of assets that pass to a spouse or a trust for a spouse. There's not going to be a tax that's required to be paid at that first spouse's death.
A good follow-up one is another attendee says, does the fact that Washington is a community property state make anything easier or simplify the process at all?
I don't know that it necessarily makes anything easier or simplifies the process. Certainly some spouses will execute community property agreements whereby they, can transfer any assets they want under that agreement to the surviving spouse, but that's only good between the two spouses. So when the first spouse is gone, the assets flow to the surviving spouse, but then at the second spouse's death, you still need a will or a revocable trust in order to make the assets flow to your other beneficiaries. But with that, please do email me if you have any additional questions, because I have to hop off here in just a couple of seconds to get on another call.
Okay, no problem. We'll make sure that the last couple questions on here get answered in our follow-up email. I'm going to go ahead and drop a survey into the comments, and if our attendee wouldn't mind filling that out, it's just helpful information for us as we do programming planning. Thank you so much for your time and your expertise, Tiffany. These are important issues that we should all be thinking about, and I may be a little behind on my own planning, and this shined a little light on that for me.
Well, you're not alone, Beverly. I appreciate that. Thank you so much for having me, and thanks to all of you for showing up today. And again, if you have questions, feel free to shoot me an email.
All right, we'll make sure to include your contact information in our follow-up email. And thank you so much, Nancy, for being here and for the Seattle Public Libraries helping us put this event on. It's one of a series of 3, and so we hope to see a couple of you folks at our next webinar, and we'll make sure that you have B dates for those upcoming sessions as well.
Thank you.
Thank you, everyone.